Hello everybody and welcome to History Bite number 241, dated April 29th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled The Brotherhood of Justices Brennan and Marshall. Justices William J. Brennan Jr. and Thurgood Marshall served together on the Supreme Court of the United States from 1967 to 1990. 23 years. During that time, they formed one of the longest lasting and most consistent voting blocs in the court's history. For sure, Justices Brennan and Marshall stuck together like glue. They were a formidable duo, a partnership, and their exceptional chemistry and camaraderie, and friendship on and off the bench, certainly contributed to this bond that they shared while justices of the Supreme Court for 23 years. Indeed, from the time Marshall joined the court in 1967, he found an almost instant connection with Justice Brennan, and the two certainly shared a great deal of perspectives in regards to numerous areas of the law, such as civil rights, affirmative action, their unwavering opposition to capital punishment, first espoused in the court's 1972 decision in Furman versus Georgia. Indeed, Brennan and Marshall were so close in their jurisprudence and their like-mindedness over all that clerks in both of their chambers often referred to the other one's justice as, either, Justice Brennan Marshall or Justice Marshall Brennan. All right, because like I said, they were complete and total aces. I mean, it wasn't a great deal these two didn't agree upon. I mean, don't get me wrong, they had different methodologies and certainly parted paths on, minor things from time to time. But overall, how Justice Brennan voted was typically how Justice Marshall was going to vote. Though it could not always say, the inverse could not always be said with respect to how Brennan would vote based on how Marshall would vote. Which brings to the next section of their methodologies while on the bench. Now, Justice Brennan, if you don't know much about him, he was one of the court's most successful coalition builders. Indeed, he was a master, compromise artist, and he was able to build coalitions of liberals and conservatives like no other. But of course, to build coalitions, quite often you have to do a significant amount of compromising in order to carry the day. This was something Justice Brennan was, had no issues with doing. He was willing to compromise his views in order to gain a majority, 5 justices, okay? Or whatever the mathematics would have been for a particular case if the court might have been missing a justice at the time, all right? As far as Justice Brennan was concerned, a half loaf was better than no loaf at all right? And he was willing to water down his own personal views and passions in order to get a majority and carry the day, all right? By stark contrast, Justice Marshall was not. Marshall, being a civil rights attorney and having been trained to stick to your guns until you get the result you want, was much more willing to stand on principle and go down in dissent, at least knowing that he stood for what he believed, rather than accepting a watered down compromise, okay? Which, sometimes led to Marshall dissenting in some cases where Brennan may have written the majority, because the majority, as far as Marshall was concerned, was a weak and very undefendable majority that would probably end up being overruled by a later court at some point anyway. Marshall was not known as a compromiser, and indeed, he didn't attain prominence as a civil rights attorney getting compromised. He went for the jugular. He stuck to his guns, all right? And like I said, he was far more willing to go down in dissent, at least standing on the principles that he believed in, rather than taking, a moldy half loaf, all right? That's not to suggest that what Justice Brennan did was bad in any way, shape, or form. A lot of Brennan's landmark opinions that still stand to this day are the result of compromise, all right? On the Supreme Court, compromise is indeed a necessary trait, all right? And it is a trait that Justice Brennan personified with brilliance, all right? Now, for the record, if you don't know anything about the judicial careers of Justices Brennan and Marshall, both were exceptionally liberal, to say the very least. Indeed, they probably were the most two liberal justices to sit on the court for the latter half of the 20th century. Indeed, from 1967 into 1991. From that period, for sure, they were the most liberal. And you add up the math and see the justices that have been appointed to the court from 1960 to present, all the way up until the 1990s, latter half of the 20th century. Yes, they were most certainly the court's most liberal. But liberal together does not always mean, as my previous points have made, that you all are going to always see eye to eye on things. But with respect to most of the major issues, Brennan and Marshall rarely, if ever, were at odds with one another. And that is evidenced by some of their famous sayings, when questioned and interviewed. I'll start with Justice Brennan, all right? In a particular speech that he made with respect to defending the living Constitution theory, he said, "The genius of the Constitution lies not in some static meaning that it may have had in a world that is long dead and gone, but rather in its ability to cope with current problems and present needs." And Justice Marshall, espoused similar views of a living Constitution when he was questioned about his quote-unquote judicial philosophy. Marshall said, in his typical blunt, cut no cards, spare no feelings type of way, as a judge, you do what's right and you let the law catch up. That's pretty straightforward and clear. All right. Neither one of these men typically felt constrained by text or history when interpreting the Constitution, but rather deferring to what was necessary, current problems and present needs. And does the language of the Constitution provide a remedy for the problem that's being presented, the legal question being presented? All right. Justice Brennan firmly believed that every legal wrong had a legal remedy, and he made it quite clear that it was the duty of the federal judiciary to solve those legal problems. All right. The federal judiciary today doesn't have hardly any William J. Brennan Jr.'s left. But my goodness, once upon a time, we did. And these are the jurists that, whose decisions helped push forward the civil rights movement. All right. Opened the long obstructed doors to voting. All right. And numerous other things, legislative reapportionment, greater protections for criminal defendants. All right. Brennan and Warren were the great architects of these things. And when Marshall came to the court, he provided the human touch for a long oppressed people, especially with his, unwavering and uncompromising stance on civil rights and advocating for the protection of all Americans and his opposition to capital punishment, something that he was only joined by Justice Brennan with. All right. And as the years went on, the health of both men inevitably, began to decline. All right. And, by the late 1980s, it is certainly arguable that both men were ready to leave the court. But the Only problem was, we had nothing but Republican presidents. First Reagan, then Bush. All right, and, Justice Brennan turned 80 in 1986, and Justice Marshall turned 80 in 1988. And with the presidential election of 1988 going to Republican nominee George Herbert Walker Bush, the future looked quite dim for both. Although for Justice Marshall, he might have done far better with getting a like-minded successor had he retired under President Reagan rather than Bush. Clarence Thomas was a plant who was not quite ready for harvest in the 80s. So President Reagan would have been hard-pressed to find a black conservative at that point. Weren't a whole heck of a lot of black conservatives in the 1980s. And he almost certainly would not have appointed a white conservative jurist to replace Thurgood Marshall. I made a separate video about this, so if you want to check that out, feel free. But in any way, both men, like I said, depended on each other for support. Marshall more so on Brennan for support, as, Marshall's mind, was not as strong as it was once he, passed 80 mark, as it was when he was younger, like anybody else's. Brennan, still remained pretty sharp, but, body was not in great shape. And when Justice Brennan retired in 1990 after suffering a stroke, Justice Marshall was furious at him, quite honestly, because, theoretically they were supposed to be holding out together for a Democratic president to be able to name their successors. But, health carried the day and Justice Brennan stepped down, And with the departure of Justice Brennan, who was the leader of the court's liberal wing after 1975, all the way into 1990, it now fell to Justice Marshall to take up the reins and be the leader. But Marshall's health was anything, but supportive of his promotion, so to speak. His eyes were failing. He had suffering from heart disease quite significantly at that time. And, the rest of him was failing as well. I mean, at this point, Marshall was 82 years old. And like many people, when you get to that age, things aren't working the way they did when you were, heck, even 70. So, Marshall was neither up to the task nor even able to pretend he was up to the task. And in the last term, he was on the court. And the only one in which he was the leader of the court's liberals, the court's 1990-91 term, he made some glitches, big-time mistakes, including once voting to uphold a death sentence, something he had never done in his 23 years prior on the court. He had to later write his colleagues back to recant that mistake. And it was at that point, probably on the suggestion of others, including his doctors, that Justice Marshall stepped down from the court. Basically, without Brennan, Marshall was, without his partner. And, Marshall couldn't carry the flag by himself at that point. His health was too much in decline for that. And thus he, too, stepped down not long after Brennan, just a year later in 1991. All right. And that brought the most consistent and most liberal and longest lasting voting bloc, arguably, of the 20th century to an end with the retirement of Justices Brennan and Marshall. These two judicial giants, left legacies that, it's hard to rival by any of their successors on the court. And the only rivaled by some of their contemporaries, all right, such as Chief Justice Earl Warren, Justices William O. Douglas and Hugo Black, okay? And after retirement, Justice Brennan was, of course, succeeded by Justice David Souter, and Justice Marshall was succeeded by Justice Clarence Thomas. Undoubtedly, as Brennan lived for 7 years after his retirement from the court, Brennan passed away in July of 1997 at the age of 91. He lived long enough to see his successor, David Souter, evolve from being a conservative to a moderate to a full-fledged member of the court's liberal wing. Undoubtedly, Justice Brennan was pleased with the work of his successor on the court, whereas Justice Marshall, without question, was probably not. Indeed, Justice Marshall passed away in January of 1993, barely a little bit more of a year and some change, year and 3-4 months after he left the court. He was 84 years old at this point, January of 1993, almost 85. He would have been 85 in July. And though he didn't live very long after he left the Supreme Court, he lived long enough to see some of the effects of Justice Thomas's decision-making, and undoubtedly Justice Marshall was anything but pleased with Thomas's jurisprudence, which is the 180-degree opposite of his. Thomas is an original intent theorist. All right, as far as he is concerned, if it does not comply with the intent of the framers, all right, it is not to be even considered with respect to constitutional interpretation. All right, pronounced difference between the originalism, original intent, original meaning versus the living Constitution approach. All right. So that, ladies and gentlemen, is Justices Brennan and Marshall. All right. Before I go, just to leave you with this concluding note with respect to the pronounced differences in the judicial philosophies of Justices Marshall and Thomas. I gave you the statement made by Justice Marshall with respect to how to interpret the law, whereas Justice Thomas's statement was this: unless we are adhering to the intent of the framers, or at least even trying to do that, then our decisions have no more basis in the Constitution than the latest football scores. He has a point with that too. Indeed, all forms of constitutional interpretation have their merits, their ups and their downs, but, it all depends on where one stands ideologically to decide which one is truly best. So again, that concludes Justices Brennan and Marshall and the Brotherhood that these two shared, both on and off the court. All right. A great friendship and a solid voting bloc of liberalism for 23 years. If you have any questions or comments, leave them down below and I'll be happy to answer them. If you like this video, gain some insight from it, drop me a like. I greatly appreciate that. And if you have not subscribed to my channel, please do so now. Your support would be tremendously appreciated. Thanks again for listening so much. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.